Welcome back to Wake Up America. I'm Sarah Williamson. Now, the trial of Kim Potter for the death of Daunte Wright is well underway. The case hinges on the defence's claim that Potter had mistaken her firearm for the taser. And now Potter is taking the stand to attest to that fact. Now, joining us now is retired Milwaukee County Sheriff David Clark and military defense attorney Davis Younts. Gentlemen, thank you so much for joining us here today. Now, I really want to start off with the big question here, the one that this whole entire trial really does hinge on. Do you think that Potter's claim of mistaking her pistol for a taser in this situation really does hold any weight in this case? Davis, we'll start with you.
Sure. Well, I think that her testimony is going to be critical today. I think she's going to have to speak directly to what was going through her mind, what she was thinking, and what was happening in the moment of a very difficult situation. So I think her testimony is going to be absolutely critical to the defense case for her to establish that. She's an experienced police officer, but my understanding is this was the first time in 26 years that she'd ever had to pull a taser or her handgun. So I think the jury's going to need to hear from her.
And David, what are your thoughts on this? How do you think that this is really going to hold up during this trial?
First of all, I can't believe this is in a criminal court. This is why we have tort law. There are several defenses to prosecution where a prosecutor wouldn't normally charge. One of them is a mistake, an honest error, and that's what this was. It's evident to me by the statement she made, which in the legal term is an excited utterance. After she fired, she said, "Oh my God, I think I shot him." That was made in real time, in the moment, so it negates a state of mind of intent as far as I'm concerned, but that'll be up to a jury. But look, all this stuff about how could this happen, I've investigated officer fatal uses of force. It's easy when the adrenaline kicks in, your sensory shuts down. It's more just reacting. You don't feel things. You know, I'm hearing that, well, the gun weighs more than the taser, the handle's different. That capacity shut down once the adrenaline rush kicked in. So I think, too, she's going to be her best witness because she was there, and I think the jury will see. And that's why it's important for her to take the stand. They'll see that this was an honest error and not doesn't rise to a level of criminality.
Now, David, I completely understand what you're saying here, and I am absolutely no expert when it comes to this, but prosecution has taken the stand, and they have argued this has all been argued in court. I just want to get that picture back up on the screen, if we can, of that taser and that gun, because this was actually what they were arguing in court is the difference between these two instruments. The taser is yellow, the gun is black. They're different in weight, the triggers are different. The taser is on one side of the body, the firearm is on the difference. I mean, when you're a police officer, and I'm sure that the police have been taken so many precautions to make sure that this doesn't happen and ensure that every safety measure and precaution has been put in place to ensure that these highly trained professionals do not make this kind of mistake. And if it is that easy, why hasn't this happened time and time again?
Well, I can't answer that question as to why it hasn't happened time and time again. But look, these things happen under circumstances that are tense, uncertain, and rapidly evolving. And that's why I talk about that adrenaline rush. I hope the defense puts on a person who can explain what happens when adrenaline kicks in, overload, what it does to the brain. So yeah, you and I could sit here and look at those things in hindsight and say, well, look, they're different colors, so on and so forth. We're talking about in real time under circumstances that are tense, uncertain, and rapidly evolving. I've argued that we have too much on those duty belts to begin with. We've loaded them up. And that's why this stuff can happen. In a perfect world, I agree with you, but this is not a perfect world.
Unfortunately, it isn't, and these mistakes do happen, but we will just have to see how this all pans out. Now, Potter is planning to testify for her own defence. Davis, do you think that this is the right call for her in this instance?
Well, I think that in a case... Oh, I'm sorry.
No, Davis, go ahead.
Yeah, I would say from my experience, in a case like this, I do think it's critical. I'm sure she'll be well prepared. And part of the things that David is talking about, just with the experience of a police officer, are critical here. And really what the state is doing in this case is asking the jury to second guess a police officer that made split-second decisions in a very dangerous and evolving situation. So I think that if she testifies well, that will be critical to this case. I think it's also important that she has an opportunity to speak to the fear that she had for the other officers that were present. One of the things that struck me about the defense's case is they have a second defense in this case. They have a second theory where they're arguing that deadly force was justified in this case because of the risk to other police officers present. You had a police officer, Sergeant Johnson, that was hanging out of the vehicle. So from that perspective, I think it's important that she has the ability to address both what happened with regard to her decision and the mistake that occurred, but also what she was thinking. And this issue of whether or not force was justified, it appears based on the facts we've seen so far that it was.
All right, now I do want to get both of your opinions on this next question too. Sheriff Clark, we'll start with you. After the Rittenhouse trial, there were calls for cameras to be put in every courtroom. What are your thoughts on that, Sheriff Clark?
Well, in Wisconsin, cameras are allowed in the courtroom for not only civil trials, but for criminal trials. It's at the federal level where cameras are not allowed. That's kind of archaic in this day and age. The Supreme Court, though, has held, and it's their call, that they don't want cameras in the courtroom, but that's something I think that needs to be revisited. Look, the public has a right and a need to know and a right to know what's going on inside these courtrooms, and that's why I think with today's technology, the Supreme Court needs to revisit that decision.
All right, David Younts, we actually have run out of time to get your thoughts on this question, but I'm sure we will have you both on at a later date. Thank you both for joining us today on the program, but we do have plenty more still to come on Wake Up America.